Hello and welcome to Daily Politics on Trust TV. On this program, we discuss issues around politics, policy and governance. I am Hamza Idris. Justice Inyang Eko of the Federal High Court Abuja on Thursday declared invalid the People's Democratic Party's primary election held on February 22nd, 2024, which produced Asu Igodolo as its governorship candidate. Justice Eko made the declaration while delivering judgment in a suit brought by aggrieved delegates from Edo State, notably Kelvin Mohammed, in a representative capacity. The judge voided the primaries on the grounds that 378 delegates who were supposed to vote were unlawfully excluded by the PDP, contrary to the provisions of the law. The court found gross violations of the Electoral Act 2022 as amended, PDP guidelines and the party's constitution in the conduct of the primary elections held at Samuel Egbemadea Stadium in Benin. According to the judge, the evidence presented by the PDP Exhibit 1 was insufficient and lacked proof, indicating that the returning officers manipulated the results sheets. Regarding the Independent National Electoral Commission, the first defendant in the suit, the judge noted that while INEC filed a memorandum of appearance, it did not submit any further processes in the case. INEC has, however, promised to abide by the court judgment. Meanwhile, the leadership of the PDP in Edo State has called for calm among its members, insisting that the Aso Ogadolo remain its candidate despite the court judgment, saying there is no cause for alarm. It is against this backdrop we will be engaging with a senior advocate of Nigeria, Barrister Sam Kargbo, and the Deputy National Youth Leader of the People's Democratic Party, Timothy Osadolo, who will join us in the course of the program to look at the implications of the High Court judgment and how it will alter the state's political atmosphere ahead of the governorship election slated for September. Barrister, you are welcome to our studio.
Thank you for having me.
Yes, we're happy having you at this auspicious moment.
Thank you very much.
We're looking at the complexities of the issues in Edo State.
Very complex.
Yes, but before the conversation, here are some tidbits. Justice Simon Amobeda of the Federal High Court has given Justice Farouk Adamu and Justice Zuwaira Yusuf, judges of Kano State High Court, 48 hours to resign as chairman of the Judicial Commission of Enquiry on alleged misappropriation of public properties and assets, as well as political violence and missing persons, respectively. The National Judicial Council, Revenue Mobilization, Allocation and Fiscal Commission, Attorney General of Kano State, Justice Farouk Adamu, and Justice Zuwaira Yusuf are defendants in the case. Delivering the judgment on Thursday in a suit filed by the former governor of Kano State, Abdullahi Umar Ganduje, Justice Amabeda held that the NJC should stop payment of any remuneration, allowances and benefits meant for the two judges from the Consolidated Revenue Fund if they failed to comply with the order. Meanwhile, the Court of Appeal sitting in Abuja has vacated the order that sacked 25 members of the Rivers State House of Assembly who defected to the ruling All Progressive Congress, APC. The appellate court, in a unanimous decision by a three-man panel of justices on Thursday, held that the Rivers State High Court, which issued the order, lacked the requisite jurisdiction to do so. It upheld the appeal that was lodged before it by the lawmakers who were led by the embattled Speaker of the Rivers State House of Assembly, Honorable Martin Ameule. We'll now take a short break, and when we return, the conversation commences. Don't go away. Welcome back. Barrister, once again, welcome to our studio. Maybe before we go to Edo, which is our main line of conversation, we should visit Kano. A Federal High Court judge has reprimanded two State High Court justices for agreeing to preside over judicial inquiry. You know, the judge said that they don't have right to do that because they are not in retirement. They are serving. What is your take on that?
Well, this is new to me. It's just coming. I'm just. I think I've been busy.
Okay. Okay. We cut you off.
I think I've been busy. I've not been paying attention to many of these things. But I think many times the state laws and provisions regarding commission of inquiry, they specifically try to find neutral people who are not in government, and people who are not serving to be members. When you are in service, active service, you are a judicial officer, you are related to the government of the day, and most times they shield you away from it. But here is my take.
Okay.
As a lawyer, you never really know the grievance that was put before the court, which we call the course of action. It is that course of action that will give you the impetus to make your own contributions, because no two cases are the same.
No two cases.
So usually, if you are not privy to the facts and you don't really have a complete overview of the judgment, you better just shy away from it.
Exactly, and I like that. Of course, Kano, a lot of drama. Almost everything has been taken to court as far as Kano is concerned. But it's on a general note, as you said. Is it okay for serving justices to preside over commissions of inquiries, or the ideal thing is to insulate them?
It's to insulate them, because you see, political matters about politics, and most of the time the thin line between politics and principles of law are very blurred. You understand? And the wisdom is that let the politicians do their job, and there are many private people, there are very good lawyers, senior lawyers in Kano who can handle that.
And sometimes I wonder, San,
as
to why governors or those in position of political authority, they are fond of having these judicial commissions of inquiry, while there are competent courts that if you can prosecute your case diligently, you can, do that without actually heating up the polity.
If you ask me, most of the time is they playing God, and the imperial office they dramatize, because at the end of the day, after the commission of inquiry, what do you do with your findings? What do you do with the indictment? You still have to go to court. Yes, there are provisions and some other offices that say if you are found guilty by a commission of inquiry, you may be deprived of this. But to me, most of the time, it's just a show of power, and they wanted to control the tough, and being most of the time the judge and the prosecutor in their causes. Because like you rightly said, if you feel somebody has committed any crime, the most direct route is the courts. The courts are there, the courts handle it, so that when he's found guilty, there would be no other means of having to go to any other recourse except perhaps appeal. Once you've been found guilty, those findings, if they are not overturned on appeal, they are attached to you for the rest of your life. But when you have a commission of inquiry that maybe after the whole process and after the waste of resources, you go and challenge that commission of inquiry, the findings in court, and most of the time too, the court can push them aside. So to me, besides the resources, a waste of resources, it's a waste of man hours.
Yes, this may sound naive, but I am sure among our viewers, some are not aware. When you say state high court and federal high court, can we say they are of this coordinate jurisdiction?
Yes, of course. Well, the difference is the matters that they handle, but they are the same. They are of the same status.
And because I'm still, people are very much interested in happenings in Kano. When you go back to the issue of the emirate, for instance, there are quite a number of cases, I've lost count now, at the Federal High Court and then there are some at the state high court. And today, sometimes we have to call our reporters to say, okay, which of the courts is actually handling this? What role do you think the authority that manages these courts, that is Federal Judicial Council, right?
Yes.
Is there anything they can do to actually sanitize the playing ground?
Let me see the difficulty they have here, because most of the times we even want to blame the presiding justices in the zone, perhaps. You're talking about the Chief Judge of Kano and the Chief Judge of the Federal High Court. The problem is this. They are playing two roles, administrative head and judicial head. But when it comes to the function and the performance of the office of the judicial officer, you have no role in it.
No role.
The moment you've assigned the case, what he does with it is personal to him, and there is no vicarious liability or because you can't go and dictate to him what to do.
But you can report him if there is maybe abuse of privilege.
Those who are affected can report him, not you. Because when you report him, you are making a judgment because you are not involved. Because
I saw the High Court, Federal High Court judge in the case of Kano now, calling on, the president of the Federal High Court to tackle these two judges who have accepted.
No, it's a case that is presented before him.
All right.
He's not acting independent of the case. Okay. The case and the reliefs sought by the litigants is what is pronouncing. So if he finds the case of the litigant meritorious and the reliefs he is seeking are deserving, he makes the pronouncement. He makes those declarations.
Okay.
But he cannot by himself sit down and say, he reprimands those judges. He cannot.
There are procedures.
There are procedures. But mind you, a judge, the moment you go into the fray, you become what? A subject of litigation, just like they've done. If you call a party or you set up a commission of inquiry against me, the first reaction is the panel. I have the right to challenge the panel. You understand? If I see that the panel by itself has breached the law or is not constituted in accordance with the law, and therefore it is incompetent, or there is somebody in the panel that I know shouldn't be in that panel, I go to court, asking the court to exclude that person, and asking that by his action or accepting to be part of the panel and act in that capacity, he's acting in bad faith where he knows that he shouldn't be there, and therefore should ask that he should be reprimanded. If that relief is not in the case, he cannot just by himself do that. You cannot.
Very interesting. Now maybe we should move to Rivers State. We have seen ton of events today. The Court of Appeal in Abuja, it has vacated, the sacking of 25 members of the Rivers State House of Assembly. Do you foresee this? Because these are people that actually carpet crossed. Should I use this word?
It is leaving a party and joining another party is a process. I cannot just sit here and say, from this moment, I'm a member of APC. No, that's not the way.
It doesn't work like that.
No, it doesn't work like that. I would have to go to my ward, pick up a registration form, fill it, and become a member of the party. But if in the heat of movement, I say, okay, I'm going to PDP, and after a while, before I put the machinery in place to actualize that, sanity prevails, I come back, you cannot say what, I'm no longer a member of this, but because it's not by denunciation. It's not that I just say, as of today, I'm no longer APC, I'm no longer PDP, and as of today, I am ARP. It doesn't work like that. But that is not to say that is what happened. But also, there is that fundamental principle that activities and disputes within the precincts of the respective legislative houses, both the states and the federal, is not the business of the courts. It's not the business of the courts, except for what? Specific cases that are identifiable and justiciable. But most of the time, in the heat of the moment, we take everything, just like matters of politics or political party matters. You find that the moment I, as a member of a political party, is aggrieved, I rush to the court. But the court is going to say, wait, before you come, let me see, is your case justiciable? Is it one that I have the power to look into? Because what? The general principle is that party matters is not the business of the court. If they want to kill themselves as politicians, let them do.
Yes.
So, but small window that I can look into. When you come with your case, I look at it and say, okay, do you fall within this precinct? If not, I say, oh no, I don't have the jurisdiction. You understand? So, like I have said, I have not read the dispute as it's expressed in the originating processes. You understand? But from the pronouncement of the Court of Appeal, I can guess that what was presented was not one that the court that made those decisions ought to have made. But mind you, the matter doesn't end there. It's going to the Supreme Court. So let's wait and see.
Oh, they still have a right to go to Supreme Court.
Why not?
So what I'm trying to understand, San, is where is the drawing line? Because we have read it and we have reported that if there is a crisis in a political party, which is at the local government level or at the state level, and then somebody leaves the party, especially legislature, and
it's justified.
Yes, that is not enough unless you have the problem at the national level.
Yes.
So Rivers crisis at that time, there was no problem at the center. I mean, in Abuja. Couldn't that have been the reason why the PDP said those people should vacate their seats?
I think so. But irrespective of their action, until you have the court putting a finality to it, you cannot by yourself act on it. That will be self-help, and that will be dangerous.
All right.
They've taken the right step by going to court. They won at the trial level. They've lost at the Court of Appeal. Let's wish them well at the Supreme Court.
But will they have the right to now go and enter plenary, pending maybe if the PDP, the governor?
They couldn't even have pushed them out. The moment that matter is in court, you cannot. They are still members of the House. They are still.
Is it executive fiat that some people are using? People who are democratically elected.
Executive intrusion. That's the problem. Interference. That's what is happening. Because what? It suits them. Those who are fighting against this one are fighting their cause anyway. But until the court put a finality, because the right of appeal is a constitutional right. It's a right that anybody has. So if I have the right of appeal, and assuming I take a decision, rightly or wrongly, you go to court. And you have a court given a sort of what? An affirmation to your own action or to the relief you've asked. That does not mean I vacate the office. Because what? I still have time to appeal. And as long as that appeal process is pending, I am still a member of the House, or I'm still a member of the organization or the party or whatever you are, because if that is not done, if you say, okay, the moment a court makes this pronouncement, you come and push me out, then what happens if I win at the end of the day?
The lapse while you were away.
Who is going to make up for that?
Then who is actually misleading who? Or is it that the legislators who are making the laws, they feel there are certain things that they can, have the upper hand at the detriment of their colleagues?
Definitely the politicians or these combatants, they are not misleading themselves. They know what they are doing.
They know what they are doing.
Of course, they know what they are doing. It is us that they are confusing or trying to confuse.
And that's why we always want to have people like you to serve as,
Yeah, but those of us who know what it is, because here it is. Assuming indeed these people had gone to the other party. But within you sat down and you made an agreement to waive that wrong. Mind you, for them to have gone to the other party, the consequences of it is not self-executory that you could say because it's done, I can do it. You understand? Somebody has to activate that. You understand? And if they have come back into the house and they are members of the house, you've rightly gone to court to say, declare them their office vacant. Because you know you cannot on your own push them out. You need a court order to do that. And you've taken the right step, and the right step has, in the first place, affirm your sentiment or your own view on the actions they have taken. Why not wait until the full hog before you now say, all right, leave? Once the appeal process is exhausted, whatever the Supreme Court says at that moment becomes what? The law and the alpha and omega of that dispute.
Very interesting. Now we move to the main topic of the day. All these issues we discuss, they are really trending today. Okay. The issue in Kano and the one in River State. Now, back to Edo State. Election will be in September, and here we are today, Federal High Court nullifying the candidature of the PDP. What does that imply?
Let me be tentative here because this is my own area.
Okay.
When I say my own area, I think I have been part of elections and the electoral process from 1999.
That's 25 years.
I've been at the thick of it, and I would always tell people that I was also a member of the government white paper on the reforms. So most of these things are nearer to my heart, and sometimes when something new comes, I start making calls to say, this is new. Is it really what happened? What am I saying here? It will be a new terrain for all of us who are involved in pre-election and election matter, if indeed the judge nullify that election on the basis of a suit. A suit, not a member who participated in election, but a suit by delegates who felt deprived. If indeed the judgment say, yes, you excluded them, yes, what you did was wrong, and therefore the election is nullified, we would all be interested in that. Okay. Because what? That is a new one. What am I saying here? I've made the hint that the law and the all-time enduring principle is that political party matters are for the internal business of political parties, and therefore the courts have no business to do with that. No matter how infernal their actions are against themselves, the court is acts, the law says it is not your business. But the Electoral Act has given a window to what? More or less moderate that principle. And the moderation is that, yes, the party can do whatever he wants to do, but where a party conducts an election, any of the parties that participated, the members who participated in that election, they call them candidates, would have a right that he can espouse in court if the rules guiding that electoral process are spelled out in the constitution of the party and the provisions of the Electoral Act are breached. That person can come to the court and the court will hear him. He can go to either the High Court or the Federal High Court, either the State High Court or the Federal High Court. Yeah. And the Federal High Court would hear him. And that is Section 84:14 and Section 285:14 of the Constitution spelled out what constitutes a pre-election matter, which is what this is.
Yeah.
And he categorized 3 actors in that one: the candidate against the party, the candidate against INEC, or the party against INEC. Those are the 3 provisions that the court, and almost all the pre-election matters, the subject matters revolve around this tripod. But to say, yes, you were wrong, that is indisputable. But the question is your action justiciable? Can you, or can that your right that has been breached affect the election of the candidate who has emerged from that particular election when none of the parties who participated has complained? That could be a new jurisprudence. And luckily for me, the gentleman, the judge.
Okay, the judge.
The judge.
Okay.
It's my classmate and friend.
Oh.
He's a very... He's
Justice Young.
Oh, he's a very, very courageous person. Very, very courageous, very well educated. And I can tell you, within the principles of the Federal High Court, there are not too many of them who have had the courage to dare. You understand? Okay. So that's why I'm saying I'm very curious. But if you ask me from the bottom of my belly, you just wake me up and say, it is doable, I will say, no, it is not doable, it cannot be. But if that judgment is there, assuming it is there, it will be a new one. But the first thing I would have to do is to go and check, to read the judgment. I know that indeed that was the judgment. But for now, like I'm saying, I'll be very, very tentative because that will be a new terrain altogether.
All right. I will read what our reporters said when we return from a break.
Okay.
Thank you. Yes.
Thank you
very much. Don't go away. We'll be back shortly. Welcome back. If you are just joining, you are watching Daily Politics on Trust TV. Do well to follow the conversation across our social platforms on Facebook, Instagram, and watch us live on YouTube. Yes, we still have in the studio Senior Advocate of Nigeria, Kargbo. Once again, welcome to the program.
Thank you very much.
Yes, you said there are. It was curious, based on what was read earlier. I want to say that Justice Inyang, based on our reports, voided the primaries on the grounds that 378 delegates who were supposed to vote were unlawfully excluded by the PDP, contrary to the provisions of the law. Of course, they said there was gross violation of the Electoral Act, PDP guidelines, and the party's constitution. Earlier, you mentioned 3 components that will warrant. Somebody must be a candidate, somebody attacking
a political party.
Exactly.
Yeah. Yes.
So these delegates, don't you think they are actually an interested party, or their weight is not really heavy enough for them to seek redress if they feel their rights have been violated.
They do, because they carry the delegates, they carry the aspirations of the party, because they must be coming from elections.
Yeah.
You understand? For each one of them, he is what? Carrying a basket of aspirations and rights of his own constituency, where he is coming from. And therefore, if there is any wrong done to them, if there is any denial, it is not only them that are denied those rights, but also the people who voted them or chose them.
Because every delegate is actually representing.
That's what I'm saying. He comes with a constituency on his back. He is just what? The face of that constituency. So where you deny him, you deny this, his own constituency. And what I want meant, if there are 300 and what? The number you say there.
Yeah.
So you are talking about 378
Yeah.
communities, you understand, excluded and denied the rights to choose their candidate. And mind you, the right to participate in politics is a fundamental right. It's a right under the African Charter, which is also what? Actionable. But what am I saying here? I am saying we have a dilemma here, that of what they say, yes, you have a wrong. Yes, you've been disenfranchised. But this wrong or injury, disenfranchisement, what does it amount to? Does it amount to an action that could invalidate an election or the primary that has already taken place? Yes, jurisprudence have come from Samfara to say if you conduct an election from the state, you've not conducted an election at all, no primary. And if you've not conducted a primary, therefore you don't have a candidate at the election. If they voted you, whatever they vote for, and those numbers are wasted votes. That has been said, which in itself comes a little bit distinct in the definition of who I said can bring a matter concerning primaries. I have stated that for you to bring an action, and that action can be had and acted upon, you must have been affected personally, and which is, you must be a candidate. That's what the law says, Section 84(14) of the Electoral Act. And the Constitution, the God of the law, says there are two sort of what? You have two stages. You have the pre-election and the election. And in its wisdom say, this is what I recognize as pre-election disputes. And he named them a party, a candidate who what? Has a grievance against the election he participated in, and a candidate who is questioning the activities of INEC as to how they are affecting him, right? And the political party who is what? Complaining against what? The activities of INEC as to how they affect his candidates. Assuming you send in your candidate, you say, this is my candidate, and INEC refuses to accept your candidate, you say, oh no, I cannot. The party has a right to expound that right in court. And that action, that grievance, is actionable. It's justiciable. But in this I have stated, where is the voter or delegate? Where does it come in? It's not pictured here. So it would take a very creative thinking for you to now say, yes, you are wrong. And because you were in any case supposed to have been what? The mandate giver. And therefore, that person cannot just sit somewhere there and write figures and what? Choose a candidate, which is what they do most of the time.
So can we say now?
But the question is,
yes,
where are those people who participated in that election? Was it a one-man election?
It wasn't.
They are there. Have they, by themselves, gone to the court?
There is this allegation that these people that went to court, they were there at the instance
of Shuaibu, who was not a candidate.
Yes, he isn't a candidate.
Understand? He wasn't a candidate, so he was using surrogates and getting very imaginative and creative in order to chip into that. So he's coming in through the back door, you would say. But let's face it here.
Okay.
I'll repeat so that the context will be very clear.
All right.
If you ask me, if I wake up from my sleep and you say, can a voter, a delegate, a party member who did not participate in the primary have the legal standing to bring an action against that primary, I would say no. Absolute no. You understand? I would say absolute no. But as a lawyer, and with my age, all cases are decided on their facts. They revolve on their facts and the course of action, which we call what? The course of action. What questions were presented before the judge? I do not know. How were those questions litigated and argued? I do not know. You understand? And what were the responses? Assuming those delegates present that case, and you join issues with them, and you do not bring to the court the issue of their locus or their standing, the ability to bring the case will go on, because the court is what? You cannot come and tell you, cannot litigate the matter for you. You cannot say, oh, in some other ones will sit down and say, come and address me. Do you think I have jurisdiction over this matter? So
in your estimation,
yes,
senior advocate,
yes,
the claim by the Edo PDP that Ighodalo remains their candidate despite the court judgment,
it's more likely to stand.
Okay, it's not a political statement, maybe.
It's more likely to stand because it is highly improbable. I'm not saying it is impossible, but it's highly improbable.
But where will they go and get remedy now? Court of appeal?
Of course, now. They are going on appeal.
Then what about
that? Is if that judgment is there. But let me state it here.
Okay.
You see, there are issues. Usually, when a judgment is read, the case and facts, which is the facts as presented by both parties, they form the case. That is, the issues join. What is the quarrel here? You say, I did this. I say, I did not.
Yeah.
You say, this is black. I say, this is white. The case is there, presented. After the presentation, which is what the originating processes will present before the court, that is your originating summons and your affidavit, in this case, or your statement of claim, or your writ of summons and statement of claim, this person has his defense, right?
Yes.
He has his defense, a counter affidavit, in this case, if it's an originating summons or a statement of defense. After you've all settled this, you've joined issue, that is, you've all mapped out the areas of contestation, you have to what? Direct the court on what the court should answer, which we call issues.
Because courts are not Father Christmas.
Yeah, where you present issues. And for each of those issues, there had to be a finding and a decision. Sometimes you could see finding one, I find in favor of the plaintiff. Finding two, I hold and find in favor of the defendant. And for each of those findings, you could make very telling pronouncements. But at the end of the day, what orders did you make? Because you are going to now sum it up. I found for this, and therefore, this is my order. It is that order, usually, that's what they call, you now go and get the enrolled order, which now itemize the concrete decision. It is that decision actually that is going to be an issue at the appellate court.
Very interesting, barrister. The conversation, I can see the technical aspect that you want to unravel.
Yes.
But while we are, running short of time, I have like 3 questions, which I hope you can answer in maybe less than 1 minute each one.
Okay.
Where is the place of INEC in this? Because you can see that they said, the judge noted that while INEC filed a memorandum of appearance, it did not submit any further processes.
It didn't have to, and they did the right thing because their role is that of observers and make their own report. And usually, any of the party can subpoena if they don't bring.
But are we not probating and approbating?
No, it's not. These are primary.
Now, assuming INEC did not monitor the election.
That's what it is. Yeah.
INEC
has its records. INEC has its record, and those records are made available to both of the parties. And if they don't have it, they can subpoena those things and ask INEC to bring those documents. They can bring them. So any of the parties who want to rely on that can bring it.
Some people are also trying to create a nexus between what is happening in Edo and what happened at the national level.
Yes.
When Wike, when he was unable to get the PDP ticket, he remained in the party but undermined the party. It is in the open now. Phil Shaibu has lost out in the primaries. He said that all his members, supporters, should remain in PDP, and he has moved out to God knows where. Why are courts silent when they come to decide issues?
It is not the business of the court. You see, politicians leave them. If I were a judge, honestly speaking, many lawyers would avoid me because it would take the most serious case for me to what they call continence. The moment he's come with go and kill yourself over there, because what? You see, politics is an issue that by itself is indescribable, because the politicians by themselves are always contesting among themselves in their millions for one thing. Leadership. That leadership and the offices for that leadership are small.
So they compete.
They compete and use all sort of what?
Power.
Schemes.
To get it.
So you, the clever one, must always bear that in mind so that you behave and know how to make your balancing act.
All right, finally, yes. Assuming that nothing happened between now and September when the election is expected to hold, do you think INEC would recognize Ighodalo?
No, if there is an order, wrong or right,
it has to be vacated.
If there is an order and that order is not appealed against, then obviously INEC would not act on this, because INEC would have to obey the order of the court. But if there is an appeal, then INEC would have to wait for the appeal process to be exhausted. Talking for the politicians here, what I think Shuaibu and his bootsmen are doing is to do what Zuma
in South Africa
did, to say, okay, you don't want me, okay, let's see. You think I'm not important, let's see. It's weakening them, and if the other two parties are smart, it's game for them.
All right, thank you very much, Barrister Sam Kargbo, for your informed perspective from the legal angle. I wish the Deputy National Youth Leader, Timothy Osadolo, were here. The question I would have asked him would be, now some people are saying there is the hand of APC in this. But since he's not here, I will leave it for another day. Well, thank you for coming to the program.
Thank you very much.
And viewers, that's a wrap on today's package. We sincerely hope you found the conversation engaging and informative. And be sure to join Daily Politics Live airing every weekday and also our special package on Friday, during which we open the telephone line for you to comment on national issues. Bye-bye for now. I'm Hamza Idris.